Good afternoon. My name is Ronaldo Hilton, the Chairperson Designee of the New York City Loft Board. Welcome to our January 17th, 2019 public meeting. Happy New Year, everyone. Section 282 of the New York State Multi-Dwelling Law establishes the New York City Loft Board. The board is charged with overseeing the conversion of interim multi-dwelling buildings from commercial and manufacturing spaces to safe, rent-regulated residences that comply with the minimum standards of safety and fire protection stated in Article 7B of the New York State Multi-Dwelling Law. To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks the progress of each building undergoing legalization, and prosecutes parties who violate the loft law and the loft board's rules. There are two separate meeting minutes which must be voted on. We first turn our attention to the vote of the October 18, 2018 minutes. Are there any corrections or comments on the minutes?
Yes. Under my name, it should be manufacturer's representative.
Would you like to be on?
Yeah.
We will fix that, sorry.
Thank you. Are there any?
Yeah, on page 5, there's a, I'm sorry, very long comment by me. The fifth line, including units that were considered to be in a basement that was perhaps as far below the ground as the step here in the security room. I think that should be hearing room. And the step I'm referring to, and obviously that step. And page 11, my only other note, 5 lines from the bottom. That is to say, if I'm an owner with 2 units above ground with windows and exit fine, it qualifies as an IMD. It should be those units qualify as an IMD, not it.
Any other corrections or comments on the minutes? Okay, do we have a motion to accept the minutes with those corrections? Mr. Hernandez, is there a second? Mr. Carver, Mrs. Rivera.
Mr. Carver?
Yes.
Mr. Barrett?
Yes.
Mr. Bruce?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
Yes.
Mr. Schechter?
Abstain.
Ms. Torres?
Yes.
Ms. Grossman?
Abstention.
What?
She's abstained.
Chairperson Hilton?
Yeah.
7 in favor, 2 abstain.
Thank you, Mr. Rivera. The next is the vote on the November 15th, 2018 minutes. Do we have any comments or corrections on those minutes? There's no corrections or extension, do we have?
I just have one question, which is on page 14, there's the outcome of the executive session where we discussed 255 18th Street. And my question to Ms. Balsam is, are you going to make a report on 18th Street in your report?
So I had not planned on it, but I can.
Okay.
Do we have a motion to accept these minutes? Mr. Carver and Mr. Barrett did second.
Mr. Carver?
Yes.
Mr. Barrett?
Yes.
Mr. Bush?
Yes.
Mr. Hernandez?
Abstain.
Mr. Delaney?
Yes.
Mr. Schechter?
Abstain.
Ms. Torres?
Yes.
Ms. Grossman?
Yes.
Chairperson Hilton?
Yes.
7 in favor, 2 abstain.
Thank you, Mr. Rivera. The Loft Board staff has prepared and now will present the 2018 annual report. Ms. Balsam will begin.
I'm gonna have to ask the board members who are sitting in the middle to move so you're not blinded when I open the check. So there.
By the way, you do have board members' presentation on your desk.
I knew that was gonna happen.
Does it work? You have to push the power.
Close it.
Yeah, coming up. It's coming up.
And then we'll move on the other side.
Turn the, no, use your back to the board, just so the public can see. You're blocked. So if you just stand to this side,
Oh, I see.
and then turn.
Okay. Can I
Yes.
stand this way?
Either way.
Because I have to push the button.
Just turn, yeah. It doesn't matter where you turn. There you go.
We good?
Yeah.
Sorry. Then I have to find a chair. It's fine.
She should just.
No, I'm good. I like to present standard. Okay, end of year report. So in the past, I've done all of the talking, and I decided this year to let the staff do some of the talking, and since they deserve the credit, that's appropriate. But I'll give you a brief overview of some of the things. Our current inventory, and I've tried very hard to count correctly, I believe it is 340 buildings. I was missing 8, and I went on a search to find them, and I think I found them. We added 6 buildings last year, and we removed 19. There are actually 2 buildings. We actually, 2 of the ones that the board issued removal orders for, there are reconsiderations pending, so they're not quite gone yet. But we did issue 19 removal orders in 20 cases. And in terms of cases considered, we decided 120 cases. As you can see, the removal cases were a huge part of our portfolio last year, and we tried very hard to work and get as many buildings out as possible, and we will continue to do that this year as well. 55 summary, 30 masters. The 30 masters is a big jump from the year before. Summaries are a little lower, but masters are up. Masters are harder than summaries, it's just the way it is. And 16 reconsiderations and appeals. In terms of cases decided by month, I just gave you a breakdown. I'm not going to go through every month. The important thing to understand on this slide is that the numbers here are not going to match the total number of cases decided, because some cases are considered in more than 1 month. So the board didn't, for whatever reason, couldn't resolve a case, or it was on the calendar and table. So that those cases will appear in the numbers more than once on this slide, but in terms of ultimate decisions, they're only decided for once. In terms of the breakdowns of the kinds of cases that we decided, you can see, not surprisingly, that the coverage cases are still our number 1. Down there on the bottom, the TR cases. And close second last year was our LEs, which are the removal cases. So that's a breakdown in terms of what calendar they were on, were they summaries, were they masters, and how many of them there were. And finally, we have a breakdown of the removal cases, and I really drilled down into the data as much as I could. So we have 130 units that were withdrawn, but remember that 130 IMD units, of which 41 of them remain rent regulated, but just note that the 41 doesn't include the 2 cases where there were reconsiderations. So on one of the cases where there's a reconsideration pending, that would be 3 units. And on the other case where there's a reconsideration pending, that's 873 Broadway on the top, it says 22, and I think almost all of those 22 units would be rent-regulated units. But they're not quite there yet, so I did not include them in the total. But when these buildings originally came, there were a total of 130 units that were IMDs that were registered. Okay. In terms of cases of interest, these are cases that the board decided. The first case that I chose to highlight was a case where the 10th floor of the unit of the building had been covered under 281.1 of the dwelling law, and there was an abandonment finding in 1995. And then a tenant that came later tried to file another coverage application under 281.5 and pursuant to the law, and pursuant to the law, the board found that the 10th floor could not be re-regulated, and the courts have held that once it's abandoned, that's it. So you don't get to file again under another section of the law if the unit was already an IND and there's been a buyout or an abandonment. The second case was the condo, where the board rejected an argument from the condo board that non-owner occupied units should not be rent regulated. Again, that's the 583 Broadway case. There is a reconsideration pending on that case. And so there would be 3 units that would be rent regulated. And then the third one was the 72 Warren Street case, which was a case of first impression, also actually a reconsideration pending here too. So the board found that the building owner had unreasonably interfered with the tenant's use of the unit when the tenant was dispossessed for 11 months after the owner had said it was only going to take 3 months. And the board established a 3-part test in terms of what could constitute unreasonable interference. And so that was the case that I chose to highlight. Because it was the first time that usually those cases settle, so it's the first time the board actually got to decide the issue. So I'm going to turn it over to Martha Cruz for the application statistics.
Before you go, can you just show me what button?
Oh, yeah.
It's the arrow button. Okay, great, thank you. So these numbers that I'm presenting to you now are as of December 19th of 2018. Breakdown of the pending applications, we have 208. 139 of them are non-coverage and 69 are coverage. Breakdown of non-coverage applications pending right now. The big ones are protected occupant cases, elite cases, and rent dispute cases of 27, protected occupant at 36, and removal at 28. Next slide is breakdown of pending applications not requiring transfer to oath. We have 8 in administrative appeal. Those are cases that are appealing administrative determinations by the staff. We have 28 removals that are also done by the staff. We have 9 reconsideration. Reconsideration cases are cases in which someone is appealing or asking the board to reconsider its prior order. And an RA application are applications where owners are seeking rent adjustments based on code compliance costs. And those costs do not become part of the rent. They are just a side charge that owners can charge. Next slide, we have applications that have not been forwarded to oath. We have 3 in this category. We have 1 defective application that will continue now to the applicant. And then we have 2 that are still in the answer period and will be transferred to oath at some point after the answer period. We have applications pending at oath. We have 69, non-coverage are 46, and coverage are 23. Master cases returned from oath. This is what I commonly refer to as post-hearing, post-settlement. We have the largest group here, coverage, which is 10. Next slide is summary cases returned from oath. We have 35 in this category. The 3 access applications are on today's calendar. We have 10 protected occupant cases, which are on today's calendar. We have one rent dispute application, which is also on today's calendar, which is included here, 3. We have 2 diminution of services applications. We have 3 non-compliance with the legalization timetable applications, and we have 14 coverage on this list. Other cases that are involved in litigation, we have 22 of them. 18 of them would have to do with Plymouth Street, which is involved in a Cape Court case, which is before the appellate division at this time. Then we have 3 others that are involved in outside litigation. 18 are Plymouth Street cases, which are being held up until we get the court's decision. I also wanted to talk to you a little bit about this case, Bridge Associates of Chicago. This case involved in a building that's been an IMD since 1993. The building has 14 units. This building has only reached one milestone. It's only filed, the owner has only filed an application, alteration application back in 1993. The registration for this building has been delinquent since 2009. The current owner of this building filed a motion in bankruptcy court seeking relief from the court to sell the building free of all liens and claims, including possessory rights of the IMD tenants. The owner argued that the tenants were holdover tenants that weren't entitled to possess their apartment or live in their apartment indefinitely. And alternatively, the owner also argued that the court could compel the tenants to accept buyouts for their rights, for their Article 7C rights. In the court's decision, they found that the owner was not in compliance, so therefore he wasn't entitled to collect rent, and that the tenants had a right to stay in their units pursuant to Article 7C if their unit was their primary residence. The owner has appealed and will wait. Oh, one more, there you go. The owner did involve a law court order. Tenant sought coverage pursuant to 281.1. The window period for 281.1 is from December 1st of 1981 since April 1st of 1980. In its order, the board found that the tenant failed to prove that there were 3 families living independently on the first day of the window period, which is April 1st of 1980. And the appellate division upheld the board's decision. Yes. Any questions?
So the next few slides are going to just discuss in terms of the course of what we've done in the past and also the enforcement measures that we've started in the present. So this enforcement type breakdown basically tells you that there were 168 monthly report violations sent out. Again, 10 for the famous reviews, 42 housing maintenance violations, and then 7 late sales filings. And then you'll see there are 5 violations that were sent out for failure to have the IPOs posted in the building. And just so you have a comparison, for 2017 numbers, there were 24 monthly report violations issued. That's when we were kind of the first initial stages of starting that measure. There were 20 in 2017 for FO cases, 7 housing maintenance violations in 2017. We had 0 violations sent out for failure to timely file the monthly reports because we didn't start that measure until 2018, and then 5 remain the same for the failure to post IMD notices in 2017. So in terms of the monthly reports, the breakdown is, as I mentioned, there are 168 violations issued. Of those, 18 violations were administratively closed. You'll see about 76 violations were cured, meaning they resubmitted the report that they were missing, and so we closed out those violations. And as of 2018, we had 72 administrative determinations. Those are where we actually imposed a $1,000 fine for missing a report. And just a further breakdown, you'll see that there's an outstanding total of $37,000. That actually is the 35 of that outstanding $35,000, of the outstanding $37,000 were fines that we actually issued. We sent them out in November. So whenever we send out administrative determinations, owners have an opportunity to appeal, and that appeal deadline doesn't expire until tomorrow. So technically, they're not required to do those.
Mr. Snow, could you just explain again the second bullet, administrative close?
So those were, those took time to be administratively closed if there was an issue where the violations were accidentally sent out that they actually did submit the report for whatever
We just made a
counting. It was an error, and then we corrected it.
Sometimes they'll submit a report under one address, but we have it in the system under another address, or we just missed it, or whatever, so.
Your comparison to 2017, you gave a number for monthly reports, but how,
It was 24 violations we sent out for failure to submit the monthly reports.
and this year we did 168.
Right, yeah, we have the more system.
24?
I'm sorry.
24?
24 in 2017. So in terms of the enforcement plan, if you last recall, the first time I did the presentation, just laid out the different measures that we were proposing, cooperative versus punitive. Again, as you can see, the cooperative measures are informational, warning letters, conferences, owners informational sessions, and then we also have the punitive measures, which are more fine-based or litigation-based. So when we were deciding to try to figure out what's the best way to come up with a strategic plan to implement the enforcement plan, we sat down and what our goal is to be very proactive. And also the whole goal is to help owners or induce owners to progress along the legalization process. So in our strategic planning, we decided to focus on 27 buildings across the 5 different milestone categories. So the first one, no all one file, that's the very beginning of the race, so to speak. And then the end is just buildings who have final certificate of occupancies, but they don't have a removal application for the law court. So first they can't be removed. So in terms of the breakdown, we looked at buildings in the different 5 categories, but the ones that have been with the law court the longest, so the oldest buildings. So we had 5 buildings in the no all one category. We had 1 building for the all one filed, but no narrative statement or no law court certification. We also had 5 buildings in expired alt 1, expired TCOs, and again, we actually decided to just reach out or target every building that was in the C of O category with no removal application filed. And then we also have 1.
So is there a breakdown between expired TCO and CO removal?
I'm sorry, can you say that again?
You're moving against 27 buildings, and in the first 3 categories, you've got 11. So that leaves 16 in the other 2 categories.
So it's 10 for the C of O, 5 C of O, no removal, and then, did I say 5 for the expired TCO? And then you'll see that there's one didn't make it back. It's actually in the 7B, 7B compliance, but that's, since it's a certificate violation, looks like we're going to proceeding against that. So in terms of what we've actually done, so in terms of cooperative measures, we did hold a conference with 1 building owner who had a final CO but no removal application was pending. We actually met with the owner and the owner's rep twice to kind of discuss what could be done to get them to move along the process. And then that issue was, it was just the final CO didn't reflect the number of units that we had. So we did meet twice to discuss what could be done so they can move on to the next phase. And then in terms of we also issued a violation for failure to update owner's information. That was one of the more of a helpful measure that we suggested to allow for further enforcement, because if owners fail to update any contact information and change of ownership, we can of course initiate any actions or issue any violations against them. So we actually did issue 1 violation for that, and we drafted the notice of violation. We also had follow-up conversations with owners who were in the final, who had a final CO and no removal pending. So again, talk to them to figure out what we can do and what they can do to progress to the next step. And then also we are in the process of preparing cases to refer to oath. This would be more of a punitive litigation measure. We've identified right now at least a couple of buildings that we hope if we have to, we'll progress to the next stage. And we have templates for all those, those proceedings, things like that, so it can actually happen. And then, which is the senior, will issue failure to take or reasonable necessary action in those proceedings. So.
Sorry, the last bullet? Sure. How are you going to issue that? You can just use
Yes, so to actually start, and I should say, I did this out, so thank you. In terms of warning letters, we sent out 22 warning letters, so of the different categories. We sent out letters to each building owner saying that this is the stage you're in, this is what you need to do to move on to the next phase. Please do whatever, the call to action we asked for, and let us know if there are any issues. So we have gotten some responses to that. But for those who don't respond, or we feel that it's necessary to take it to the next phase, to initiate any kind of violation or in subsequent fine, we have to do actually set out a notice of proceeding to the owner, saying this is the rule, if you violate the rule, this is what we have, and it allows them the opportunity to give a response, and then from there, we send them for trouble.
You said 22 warning letters, is it 27?
So,
27 from the building?
27,
Yeah.
right. So of those 22, we sent out warning letters to different categories. One of those we're looking to commence, to refer to O for potential housing maintenance violation, that's 25. And then one of the buildings we also selected potentially to be did both a warning letter, and if they don't follow up, again, refer that to O, so that potentially be the one we would take to start actions for failure to take over the necessary action against. And I think that should account for all.
Is there a phase 2 after the 27?
So right now, we sent them out, it hasn't even been a month yet. Some, depending on which stage, like the one building has the one that filed the alt one, but no Loft board certification narrative statement. Their call to action was submit a narrative statement, so I think we gave 45 days. So we're waiting for that time to elapse. So most of the buildings had 30 days, some had 60 days. I think for the ones who had final CMOs but no removal application, we said please submit your removal application within 60 days. So once those elapse, we'll review and figure out what the next step should be.
So now sorry, my last thought was, so then you'll be updating in the public hearings, what, after 30 or 45 or 60 days, like what the next step is? Or is this just an annual review?
This is an annual report, but if the board wants more data, we can certainly do that. I think probably in terms of enforcement, quarterly would be better.
Quarterly sounds good.
Okay. And let me just say a couple other things on the failure to take all reasonable and necessary actions. So we have a rule that talks about failing to take all reasonable and necessary action, and there's two different paths in the rule. For some of the violations, you don't need a hearing at oath, but for others you do. So for the test cases, we didn't want to do a lot of the ones where you have to prosecute them as at oath. We chose the test case to see how that's going to go, and then we'll see what we're going to do in terms of other buildings.
The Loft board issued 74 certifications. That means that we issued 5 initial, 65 amended, 4 partial. The initial means that if we had an IMD building, they're now allowed to begin legalization work. That means we now went through file a narrative statement, went through the tenant review process, DOB cleared, went through the DOB final exam process, and either tenants and owner came to an agreement, or a clock was issued, and no compliance or more comments or alternate plans were filed. We issued 65 amended, that mean new work in an owner-occupied unit, vacant buildings. Partial, issued 4 partial for no gas, no heat, meaning a unit from a building didn't have gas or didn't have heat, so we issued 4 partial certifications. For loan requests, we issued 30. We received 346. We granted 281. We denied 53. We rejected 8 because they were incomplete, and we rejected 4 because four of them were not IMD buildings, so they weren't subject to all 4 rules. A loan is required to do work in a commercial unit. It's required to do work in a non-IMD unit. It's required for a common area work that's not legalization work. what staff makes, we look to, we make sure that the owner, when we are granting these, 281 also includes approvals for DOB equipment, like sidewalk sheds, safety measures, and what staff looks to is making sure that the owner has approved all one, and they're going through the annual statement process, and they're up to date on their registration fees.
The rejected ones were not an IMD. Why would we have gotten?
And in the past, it's possible that for these four, they were loft buildings, and for whatever reason, it wasn't reflected in the bid system, so the loft board requirement came up. There was nothing for us to issue because the building was removed, so I sent the expediter with a loft board removal order to demonstrate it's not an IMD.
Okay, and the ones that say incomplete, just read incomplete, do you have a sense of when those, were they towards the end of the year? Where
Spread out.
Spread out?
They haven't,
They haven't really come back to you?
it could mean that they haven't read their objection sheet, it could mean that they're waiting for one for approval, it could mean that we're waiting for them to file an error statement or to file an error statement or to renew their one permit. Those are all reasons why we would deny someone a 101.
Just since the numbers are so small, can you just do a quick, when you get a chance, get around to it, just kind of revisit and see what's going on there.
Staff held 30 narrative statement conferences. We also met with the owners of building subject to vacate orders to understand issues and assist if possible in having vacate orders lifted. We did that for 3 and 4 of the buildings. We also met with the owner of 583 Broadway. Your slides may say 873 Broadway, but we met with the owners of 583 Broadway to discuss the owner's removal application. We also met with tenant and owner advocacy groups and politicians to discuss various law issues. We met with the building owner and the DOB to discuss structural issues at 40 Dover Street in Manhattan. We also met with the Borough Commissioner's Office regarding issues at 72 Warren Street. And we also met with DOB auditors and the owner reps for 89 Commercial Street and 207 Star Street to discuss their all-one plans, which are under audit. Other projects? If anyone has any questions, they can start. Other projects, we assisted in developing project guidelines for legalization of loft buildings. We were very excited about it. We also worked with the DOB Media Relations team to design the Loft Board website. We worked with the DOB Analytics team to develop the Loft Board map. We trained new planning members and new inspectors for them to understand what to look for. We also trained 2 board members. Welcome. Thank you. We also presented at the Law Department's Administrative Law Division lunch meeting. We also developed a comprehensive spreadsheet of buildings removed for lawful jurisdiction, for orders. We worked with the city planning on proposals regarding South NoHo, and finally we drafted and presented a resolution to family members and former board member Ronald Spatafora. Rest in peace.
And the Loft Board staff took 4 visits this year, 79 Norman Street. Loft Board staff went with the Department of Buildings to see if we could get a vacate order lifted. The vacate order was in fact lifted. 517 West 45th Street. Loft Board staff responded to tenant complaints that the elevator was not working. Staff went out and verified that the elevator was in fact working. 255 18th Street. Staff responded again to tenant complaints. Staff went out with BSA, and BSA did in fact revoke the certificate of occupancy for that building. 350 Moffat Street. Staff went out to discuss issues with the commercial tenant, and the owner actually filed an Alt-1 to legalize the residential spaces in the building.
question. I thought at one point we were going to revise the board of these reviews of these buildings and that we could perhaps participate.
The New York City Loft tenants had asked to have board members tour buildings, and they are supposed to give us a list of buildings that we will vet to make sure that there's nothing pending. They have not given us the list yet. We have another meeting scheduled with them next week. I'm assuming that they will give us the list.
Okay, thanks.
With regard to the staff field visits, is this separate and apart from our inspector making visits?
Yes.
Yeah.
I just want to say also on 25518, if we didn't want to visit, but the staff presented in support of DOB's application to Oklahoma Road, presented a good job in presenting right here to BSA, which was granted that very same day, revocation order.
Total revenue for 2018, $1,523,034. You can see the majority of that coming in June and July, which coincides with the annual registration of the buildings. We had 382 FOIL requests processed. Slide breaks them down month by month. Other FOIL issues, we worked with the General Counsel with 2 FOIL appeals arising from requests to the Law Board. Staff was also trained to do clear will searches for emails. That's a new application that we're being trained in. We can basically go into not only all of the staff members currently working, but previous staff members. We can go into their emails and search the emails with a range of dates and specific keywords that can help us respond to FOIL requests. Additionally, we supplied certified copies of law board records pursuant to 7 subpoenas.
So just so I understand, for the clear well searches, are you going to archive emails of even staff who may have left?
Yes.
Board member?
I don't think we have access to board members' emails. There might be some communication between staff and board members, and if that happens, then we might follow up research.
I don't think we've ever gotten a FOIL from board member emails.
So the Clearwell searches are only tied into FOIL requests?
Correct, yes. The clear searches are made in response to FOIL requests. So like, we've had FOIL requests for Lanny Alexander emails. So you do that through a clear search.
Yeah. Okay.
Okay, rulemaking, the board approved the draft of Chapter 1 with 1 open issue pending discussions on decisions on Chapter 2. The board discussed proposed Chapter 2 changes, and so far we have agreed to add code compliance deadlines based on 2015 amendments, change the narrative statement procedures to make them a little more tenant-friendly, add rules and penalties for violating a Loft Board order and filing a materially false statement with the Loft Board, and allow the owners who would otherwise be precluded to file for extensions or code compliance deadlines. Staff also continues to work with City Hall on rulemaking issues. Finally, legislation, the Law Board staff work closely with the staff from the City Hall Office of Legislative Affairs and state legislators on proposed amendments to the law. The Assembly passed the bill, and the Senate did not consider the bill as of yet, so we will wait and see. That concludes the annual 2018 presentation.
Thank you. Well, I just want to say thanks to the staff. As you can see, there's quite a bit of stuff that was accomplished last year Thanks, Elaine, thanks to our staff for your hard work. I just want to toot their horn a little bit because I know FOIL, in particular in FOIL stuff, I know FOIL has been a very contentious thing in government where, you know, usually it's just you have to wait a long time before your FOIL request gets answered. The Loft Board has a zero backlog in FOIL, in fulfilling FOIL requests. So I just want to say thanks to that. That tells us that we are on the ball. And for all the other stuff that we've been doing, the Loft staff that has been doing, you know, in answering community-wise, just kind of responding to a lot of different things, as you know, with the effort to revive the Loft law back in Albany. That's completely out of our scope and stuff, but we've been working very hard with all involved and the politicians and so on, just to assist in trying to perfect the law that is going to be introduced this year. So I just want to say thanks to the staff. It's been a lot more than what you guys were thought you would be hired for, but thank you for everything. Appreciate it.
Before we move on, I'd like to spend a couple minutes just reacting to this very comprehensive report. And my first question would be, I assume the PowerPoint that you presented is a public document.
Yes, it's going to be posted on the website.
Yeah, and good, I was going to say, and in addition to posting it on the website, if there's some, let me back up a second. Sometimes the board is criticized by various interest groups for various reasons, and I think the broad scope of the activities that the board undertook in 2018 is something that maybe the half dozen people in the audience had a chance to hear about. But I think that what's contained in here really should be not only posted on the website, but if there's a way to kind of make its existence known, I think that would be very helpful for the board's reputation.
You know, I like that idea, but I'm just kind of curious if you have any idea, any suggestions.
Well, a couple of things. Some of it, what we looked at is insider baseball, so you need to include a definition of lono.
Oh, yeah.
Anybody out there know what a lono is? Yeah, we got one, two, see? The
letter of no objection.
Yeah, the numbers that we got comparing the 2018 activities with the 2017 activities, I think should be put in a column so that people can see the increase, maybe a little history of a couple years regarding the amount of money the board collects. I think, and I'd be happy to flip through this again and send in some suggestions for ways that I think you could amplify it that would make it clearer to people who don't sit through what we do every month.
Sure.
I appreciate that. And, you know, maybe what we need is a PR person on staff. Yeah, appreciate that. Are any other comments on this?
Yeah, I do. One of the projects on the list was the DOB guideline project that you were working.
Yes.
And I know you had recently circulated it to us and asked us for comments.
Yes.
I think today is the deadline, and that was today.
So I think we had asked for comments from the board members by today so that we could prepare comments to give to DOB by next week.
Oh, I see.
The deadline for DOB is next week, but in terms of the board collectively submitting comments, I think we wanted them tomorrow. I think yeah.
No, I asked only because the document has been a large and dense, and I was wondering if we could have more time, but it looks like we have a very limited time frame. All right.
I agree.
It's kind of highly technical too, so I don't know.
Yeah.
I mean, but just, I mean, do you need more time to look at that?
Yeah, but I think what I'll do is I'll send it through whenever I have them, and if they get read, that's nice. If they don't, they don't, and what do we do?
But it's important, you want to be,
Share them.
if, you know,
Please don't share them.
you mean just send it
I
to,
don't know how much time it should.
Send it, yeah, to us, to give to DOB, yeah.
Yes,
Yes.
yes, and keep it.
Keep them to
Leave them,
yourself.
leave them on the sidewalk. Kidding.
I was actually going to ask about the guidelines, but,
It's on my report.
okay.
You can
So,
ask now if you want.
and just to close out on the end of your report,
I had something too about the end of year.
your little quick comment, Ronaldo, about having 0 outstanding floor requests, that damn well should be in here. That's a very impressive piece of information.
And let me just say that it's our unbelievably hardworking public information officer, Michelle Shepard, who handles all of this. And when I first came to the Loft Board, I was amazed at how many FOIL requests the Loft Board really gets. And I came from a very large agency that got a really minute number of FOIL requests. So it was shocking to me to see how many we actually get. And she is just fantastic.
So, yeah. Oh, I was just gonna ask, I'm not sure if this works. Does it? Yeah. I read an article that Commissioner Chandler's retiring
Yes.
February 1st.
yes.
So I was wondering if the end of year report, like, I mean, it could be used to help explain what we do to the new, I don't know, is there,
Oh, you mean to the-
there's gonna be a temporary,
You mean to the new commissioner?
yeah.
Well, the report that you heard that from the mayor's office that Commissioner Chandler is retiring at next the 31st also says that the acting commissioner will be the first deputy commissioner who's very intimate with Loft issues and so on. So there's been in terms of him leaving, in terms of changing the guard there for now, I think. But this report could be available to a new commissioner to kind of orient them, and I guess that would be our job if and when that person comes on. You know, we could use this. Are you suggesting that this could be a good tool to orient the person on what we do at the law?
Yes, and I'm also not sure how long there's a temporary,
Well, we don't know. That's you know.
could be.
It could be. He could act or be appointed, or there could be another change. Yes, but we just don't know. That's the mayor's office.
Wouldn't it be a bad idea to invite the commissioner, or new commissioner to attend the meeting if they so desire?
Certainly. We could.
I think it's so important.
He was a chair.
He was the chairman.
He was the chair for a while, Tom Ferriello.
Yeah, well,
Well, he didn't say so.
No.
Oh,
no,
okay.
No. And, you know, Commissioner Chandler, we've never seen.
Yeah. All right. Well,
you know.
I'm his designee.
Former commissioner used to chair the meeting.
Yeah,
Yeah, some former commissioners, at least one we know, actually chaired it.
Chair the meeting.
Yeah.
I just have a question about the flow of cases and the number of cases. We have lots of good stats here, which is nice to see. And I assume that with no more coverage cases being taken in, the number of cases might over time shrink. I don't know if you've yet actually felt the effects, but no, not yet. But is there some thought about having goals in terms of how long you guys take from when you get a case remote to actually issuing a draft to us? And I ask this, and this is not meant to be mean or anything, but we do see the courts issuing orders to make the board vote on the case or to
Mandamus?
Yeah, mandamus, and obviously the number of mandamuses is not one of your stats.
Well, it's in there, it's included in the 22 that are in litigation.
Okay. But I mean, it's a real problem, obviously. I mean, the parties do suffer when the cases take so long. And I'm just asking if there's been any thought about having actual milestones, kind of dates that things move along.
The problem with that, and I think it's a great idea, the problem with that is, one of the things that I've certainly found at the Loft Board is that there is no one size fits all. So, you know, you want to take the Saladino case as an example, where it was, you know, multiple tenants, multiple issues, a massive record, many, many hearings. That case, I was the attorney actually that worked on that case, and that case took me months, and I worked very hard on it. As opposed to, let's say, you know, a one-issue case for one tenant, like say a rent dispute, that's going to take a lot less time. So, you know, we could try and come up with some sort of rubric that's kind of based on the extent of the hearing and the complexity of the case. You know, I would love to have no backlog whatsoever. And we have made progress. We have less cases pending this year than we did last year. And I have those stats, and we can give you those stats. And yes, the number of coverage cases is shrinking, but there's still quite a number of them out there. But yes, I agree with you that we should try and work faster. So in terms of setting standards, we can think about it and discuss it amongst ourselves.
Right.
I think it's a good idea.
You know, I'm thinking of reconsideration cases sometimes taking more than 12 months, I think I've seen. But I'm not
The reconsideration cases, we assign to a new attorney. You know, I don't know that that always happened before I came, but to me, a reconsideration means somebody else is looking at it. They'd go much faster if we just had the same attorney look at it again, but I don't really think that's the idea behind reconsideration. An appeal from an administrative determination, that's different. But the recons, I have insisted that they go to different attorneys. So that is slowing things down, there's no question.
Well, thanks.
Are there any other comments on the annual report? And I'll have Ms. Boston now present her director's report.
So the first thing on my agenda is that our offices are being relocated to the 5th floor of 280 Broadway. Our tentative moving date is February 7th, 2019. We will post that on the website, so please keep looking for further notice. We have insisted on new signage since we finally got a sign in the lobby that said Loft Board 4th floor. It's been up for about 2 months, and now we're moving. So we will have signs on the window on the 4th floor and on the window on the 5th floor. For those of you that actually deliver documents to us or are coming to us to deliver documents, the path actually will be the same. You'll get off the elevators on the 5th floor, you'll turn right, and you'll see another window. It's not at the exact same location, but it's in the same general location as to where our window is now on the 4th floor. So that's the most important thing.
This is only to facilitate construction in the building, and that's why we're moving.
Are you getting more space?
No. Better space.
Better, it's newer space.
Yes. In terms of the 255 18th Street, I just want to clarify one thing that was said. So yes, staff did go to the public hearing at BSA. Staff made an excellent presentation of Michael. I thank him for that. And BSA voted to revoke the CFO for 255 18th Street. Their decision has not actually, the written decision has not come out yet. So I just wanted to clarify that. The unofficial amount of revenue for November was $64,484, and the unofficial amount for December was $26,670. As of December 31st, we had 336 buildings that had renewed their registrations, and that figure is up from last year. Also on December 31st, DOB mailed out the project guidelines to selected architects in the Loft community. The project guidelines are designed to provide guidance to the public and the DOB plan examiners as to how to handle legalization issues for the IMDs. The comments are due back from the architects on January 25th, 2019. I do want to publicly thank Michael Bobick, who was the Loft Board liaison to the committee, the DOB committee, and I have to say, having sat in on some of those meetings, they are mind-blowing. If you're not a technical person, it's very difficult. So he did really an outstanding job. And our mantra from the very beginning was, make it easier to legalize, make it easier to legalize. That's what we wanted. So, we'll see where it goes. Again, they are not designed to talk about what's happening now. They're designed to provide a path moving forward in the future. So I just want to make that clear. One of the reasons that we started the project was that we got a lot of complaints from the architects and the attorneys in the community that DOB was doing very disparate things in different offices, and the idea was to try and harmonize things and provide a path forward in every office for everybody.
I wrote you, asked a question about the board members providing comments, and as you replied, and I think correctly, it's a professional document for professionals. So is there any way for those of us who are not professionals in that field, for somebody to provide a kind of summary of issue 1 is this, and there's been a change, there's been no change? Because looking at it, you could almost get the feeling that it was written in a way that was designed to make it hard to understand.
Well, my understanding is that there's actually a whole lot more text in our project guidelines than in any other project guidelines. And I'm an architect, I don't know if you're familiar with the other project guidelines, but one of the things that the people on the committee said was, well, we're given a lot more information here than we did in any other. And we were like, yes, do that. So that doesn't necessarily mean it's easy to understand if you're not technical. Do you want something for interim? I mean, certainly I think once they're finalized, you could definitely have somebody come in and present. I think that would make sense. But do you want something in the interim?
If that's possible, I think it would be helpful. It's very hard to tell from the 45 minutes I spent looking at it whether this states the status quo or a proposed change, and if it's a proposed change, what is it a proposed change from to?
I don't know that it does that. What it's saying is, here's what you're going to have to do. It doesn't differentiate between what was done in the past and what's going to be in the future. It says, here's the path forward once these are promulgated, or published, I guess, because they're not really promulgated, they're not rules. So it's not meant to look back and say, we have changed this. That isn't what it's about. It's about, here's your path forward. If you want to do this kind of job, this is what DOB is looking for.
Well, so we were just talking about it's a compilation of rules from the various zoning resolution, the MDL, housing maintenance code, building codes, so it's pulling the pieces from the different regulatory pieces that govern New York City that are relevant to IMDs. So it's not saying, oh, we're going to change the building code to read from X to X. It's just saying this is the section of the building code that is relevant to someone filing an application for an IMD. So these are the egress rules related to a potential application for legalization.
So,
as opposed to the egress rules for like a brand new 50-story commercial building in your town, kind of thing.
right.
Right.
So then part of the goal is, in essence, because I know I've heard in the past some concern expressed that plans examiners in Brooklyn look at things differently than plans examiners in Manhattan. So part of the goal here is to say, okay, to the extent that plan examiners are kind of like referees, here's a uniform set of rules as to how you make decisions.
Yes.
For
Right,
consistency.
but the rules already exist within the, or like each one of
It's like a
these.
cheat sheet for.
It's like a cheat sheet, exactly, so it already, it says.
But they're not cheating, I mean.
Exterior envelope, fire resistant, so this is just saying which part, referring the reader to the section of the building code that this is talking about. It's not writing the text of the building code, it's just referring to something that already exists.
Okay, and so to the extent that over the past couple of years, concerns have been expressed about sleeping alcoves, this is not looking at, here's the issue, here are the arguments on various sides, and here's a change. This is just kind of setting the benchmark for where we should be right now.
To the extent that there were policy decisions that needed to be made in terms of interpretation, those are included in the guidelines, not necessarily under the charts, but under the text part that follows the lists of the sections. I don't have it with me, so I should have brought it with me, but I don't have it with me. So I could show you specific places, but there were policy calls that needed to be made, and the committee debated and ultimately went to the first deputy, and policy decisions were made.
So there are some, if one knew how to spot them, there are some policy decisions that represent some definitive statement with
Yes.
regard to something that's been the subject of controversy.
Yes.
I think
We did, and let me just say that we did have input from both a tenant architect and an owner architect, and all of those comments that they gave us at the outset when we had the initial kickoff meeting were discussed by Michael would know that, but were discussed by the committee. So the DOB committee was aware of the issues and tried to deal with them, all of them that were raised.
so. Perhaps a distillation of that would be what would be helpful for
Okay.
those of us who are.
We can try and put something together.
Boss, are you complete?
No, actually, I'm not, sorry. Okay. We did talk about website revisions. I just wanted to tell you that they are actually continuing, and hopefully the maps will actually be on the new website, which should be happening sometime in the spring. I did also want to make people aware that we got a call from the Department of Information Technology and Telecommunications in city circles known as DO-IT. It's the city's IT department, or IT overseer. Each agency also has its own IT department, and they said that they are migrating us to a new server, and that the URL for the Loft board is going to be changing a little. The old URL will redirect you to the new server for the next 3 or 4 months, so please update your bookmarks if you have it bookmarked, so you'll be able to get to the right place. In litigation, we received 3 favorable decisions. One of them I've already sent to the board. That was the only one that we got in writing. Unfortunately, that was the case where we had a net lessee who was the son-in-law of the owner, the principal of whom was the son-in-law of the owner of the building, filed for an extension application, and we denied that because the net lessee, who is the son-in-law of the owner of the building, is not a new owner under the board's rules. New owners are only where there is a transfer of title There was no transfer of title, and it was, if there was any kind of transfer of an interest, it was certainly not to an unrelated entity for a bona fide business purpose, and the court upheld that. We had two decisions that came down from the bench, so we're waiting for the transcripts on those. One was McKenzie et al. Versus the Loft Board. This was the tenants had filed an alternate plan dispute. The Loft Board had denied their alternate plan, and they brought an Article 78 proceeding, and the court denied the petition and dismissed the proceeding. I don't have more reasoning on that. And another interesting case, which I'm sure all the board members that are here will remember, is again part of the Saladino suite of issues, was Dasa Realty versus the Loft Board. So this was the case where we had the issue of whether or not a unit was in a basement. Actually, we were just talking about it, and we were talking about correcting the minutes. And so the owner challenged the board's finding that we were going to just go with what the C of O said, which was that it was on ground, and the court dismissed the petition and denied the petition and dismissed the case. So Ms. Schwartz and Mr. Castro stay covered. Their unit stays covered. And that's what I have.
Can you, Mackenzie, is there an address associated with that?
517 West 45th Street. And Dasa Realty is 401. That's it.
Very good. Thank you, Ms. Paulson. No further questions. Okay, great. So we now turn to vote on the cases on the summer calendar. There are 12 cases on the summer calendar. Usually as a group. Today we will separate out two cases, number 10 and 11, and vote on them separately. So the first set of cases that we will vote on together are 241 Bedford Avenue, Bedford Associates LLC at 156-170 North 4th Street, aka also known as 239 to 247 Bedford Avenue, Brooklyn. The docket number is LS0240. The second one is 241 Bedford Associates LLC at 156, exactly the same. And so and that docket number is LS0241. Again, 241 Bedford Associates LLC, same address, and that docket number is LS0242. Then we have Andrew Radcliffe and Jason McDonald at 1083 through 1095 Flushing Avenue, Brooklyn, docket number PO0065. The next case is Rosalina Merview, 83 Meserola Street in Brooklyn, docket numbers PO0069 and TR1363. Next one is Elizabeth Marshall at 222 Varrett Street in Brooklyn, docket number PO0080. Next, Thomas Zoomer, 314 through 320 Dean Street in Brooklyn, docket numbers PO0081 and TA0248. Then Andrew Radcliffe and Jason McDonald, 1083 through 1095 Flushing Avenue in Brooklyn, docket number TA0242. Then Neil Sundit, Thomas L. Beer, Thomas Stephen Mayer, and Argot Mayer at 197 Henry Street, Manhattan, docket number TH0200. And finally, Marlene Simone Spiori, Madden Joksik, Misha Spiori Josic, Zora Spiori Josic, and Luca Spiori Josic, 645 Broadway in Manhattan, TR 1350. Is there a motion to accept these cases? Thank you, Mr. Schechter. Is there a second? Mr. Carver. Does anyone have any comment on these cases? There are no comments on these cases. Mr. Rivera?
Mr. Carver?
Yes.
Mr. Roberts,
Yes.
Mr. Booth,
Yes.
Mr. Hernandez,
Yes.
Mr. Delaney,
Yes.
Mr. Shepherd,
Yes.
Ms. Torres,
Yes.
Ms. Brosnan,
Yes.
Chairperson Hudson,
Yeah.
9 in favor.
The next case that will be voted, summer case will be voted on by itself, tenants of 28 Locust Street, and that's 28 Locust Street in Brooklyn, that docket number TR1272. Do we have a motion to accept this case?
Aren't there going to be some changes to the language, or no?
Oh, well,
Yep, so you want to just,
There is going to be,
The last sentence of the proposed order, we're going to delete the last sentence of the proposed order.
And did we redefine the text on that sentence? Did we say something like the owner should now submit to leases rather than?
We would take the last sentence out. We're requesting that the owner file registration materials pursuant to the Loft Board Rule 205B8 within 30 days.
with those changes made, those were requested during the prior session, do we have a motion then to accept this case? Mr. Bowers? Mr. Hernandez was second. Do we have any questions? Comments? Yes.
Yeah, I'm going to vote no on this case. I asked that it be taken up separately. And the reason I'm going to do that is the rather lengthy stipulation from the owner sets up a scheme whereby in exchange or in the discussion that led to the agreement to register the tenants, the owner has put forth and set up a separate preferential rent schedule. Preferential rent is an issue that has been of great concern in the world of rent stabilization. So the owner and the tenants have agreed that the rent should be this. And there's also an interesting building, I might add, because apparently between the time the building applied for coverage and the time the case came to us, the building got a residential certificate of occupancy. So there's a tenant's rent column in the stipulation that is a preferential rent, and then a tenant's rent plus the 18% through obtaining the certificate of occupancy. I agree that these tenants should be covered as protected occupants. I don't know what the rents should be, but I think for the board to accept stipulations with its, what I consider to be weasel wording, saying, well, the Loft Board neither accepts nor rejects the other terms of the stipulation, sets up a whole host of questions. What is the official rent of this unit? What happens if one of these people moves out and somebody moves in, and how do they know what the rent of the unit is? We have accepted many stipulated settlements using our Loft Board neither accepts nor rejects language. Some of the things that we accept are benign. Every now and then something raises to the level that even the collective Loft Board has such a bad taste in its mouth that they spit it out. And this, in my mind, is one that should be spit out, and I intend to vote no.
Thank you, Mr. Delaney. Anyone else?
Is there a way to, Chuck, like you were saying, you agree with the case, but you don't agree with the preferential rent? I mean, is there a way to parse it out?
The staff, of course, won't answer questions in the public session. So we can, I can only tell you, I don't know. But preferential rent is causing evictions all over town right now. People who discover that the real legal rent is something other than what they thought it is. We've seen this kind of game go on in the Loft Board with owners who don't file 28612 applications, leading a new tenant to believe they're moving into a covered space. What they don't know is that the space is covered in the sense that the owner's supposed to bring it up to code, probably hasn't, but that the tenant is not a protected occupant. So in my mind, setting up, for us to go along with this is just, no.
Okay. No more comments, then do we have a, Ms. Rivera? Could you?
Oh, no, we already.
You did, sorry. That motion was already made.
Right, yeah.
Ms. Rivera, can you call the vote?
Is there,
I'm
can
sorry.
there be a motion to table it until we discuss it further?
I think what Chuck says is really quite puzzling to me, and I would say at this point, I'm not prepared to vote on this. I need more information, so I think it would do well for the chair to table this.
Yes.
No, you don't need a vote.
Oh, I don't.
Well, the chair has the privilege to
No, well, that's putting, so.
Oh.
So is there a motion on the table?
Well, then we would have to withdraw.
Would that first withdraw? There's already a motion on the floor to accept, I understand, I see.
Are you saying, Mr. Barrowitz, that you can just table it? Right?
Yeah.
The chair can table it even with the motion.
Even with the motion.
I believe that.
How do we know you got that right, Mr.?
Just because to try to shed a little parliamentary light, I believe that under the board's rules, the chair can table something. But in any deliberative body, when a motion is being considered, there has to be a motion in order to have a motion to table that motion. If a motion to table is made by a member of the body and seconded, it is also undebatable. That's my recollection of Robert's rules.
You may be right, but I'm not sure of that. I think that the motion, that whoever made that motion, which is me, can withdraw it. In which case the second has to be withdrawn, in which case the chair can then table the thing, or we can go through the process of going up and down on this thing. And we're in the horns of a dilemma now. So I would say that the best thing for us to do would be to try to get this order table for now.
So the question is that we have two people who has some issues with voting for this. I mean, do we have enough of an interest in this, going back to this, discussing this case?
Well, we can take a straw ballot to see where we are.
Yeah, that's per.
Or the other thing we do is, which we've never done, is if one person calls for a sealed ballot, that's not to be discussed, just automatically happens. So if people don't want to reveal who they are in their voting on this thing, we can ask for, well, somebody can ask, I can ask for a sealed ballot. And that's not to be seconded or just automatically.
Can I just ask, who originally proposed that we vote on this case?
You mean who made the
Who made the
motion?
motion? Yes, please.
Mr. Barrowitz.
I do.
All right, so are you withdrawing your motion?
What I'm saying is that I would either withdraw this motion or ask for a sealed ballot or ask for a straw ballot.
And my question is, are you withdrawing this motion?
I would, yes.
Yep, I will try to. Okay. So now that that's withdrawn, can we move on?
Yeah, we're tabling this.
Okay.
Thank you. So the next case is case number 11. That's Emma Anderson, Daniel Venter, and Misila Carola at 792 Flushing Avenue in Brooklyn, TR 1337. Do we have a motion for accept this case? Mr. Carl, is there a second? Mr. Hernandez, does anyone have any comments or questions on this case? Mr. Today.
Yeah, yet again, I asked that this be taken up separately. Here, the tenants have, in an extensive stipulation, agreed to a number of things that I think are something that the Loft Board should not be in the business of accepting, in particular, rewriting the access rule, waiving the access, and the tenants' consent to, the tenants, as if they had a vote, in the agreement, consent to granting of code compliance waiver to the owner. And again, my feeling is that the more leeway that is allowed to negotiate settlements in front of oath that deviate from the Loft Board rules or Article 7C, the bigger an area of difficulty is created, where in an effort to gain concessions, proceedings can be drawn out, and that causes people to make concessions because the meter's running. And if this kind of gray area were either eliminated or sufficiently narrowed, it would take away that situation.
Thank you, Mr. Delaney. Does anyone else have any comments on this case? Mr. Barrett?
Mr. Carlson?
Yes.
Mr. Barber?
Yes.
Mr. Ruth?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
No.
Mr. Schechter?
Yes.
Ms. Torres?
No.
Ms. Roseland?
No.
Chairperson Hudson?
Yes.
Six and three against.
Thank you, Ms. Rivera. There are three cases on our master calendar. The first case is 383 8th LLC, at 383 to 385 8th Avenue in Manhattan. The number is LB0192, and Mr. Clark will present this case.
Thank you, Chairperson.
You look good.
Talking to myself. Thank you, Chairperson Hilton, board members. On November 6, 2017, owner filed an application seeking a finding that tenant abandoned the unit pursuant to 29 RCNY Section 10(2-10F) based on tenant's death. Although owner's application is uncontested, Section 1-06I4 requires owner to present a prima facie case demonstrating entitlement to the relief sought. The three prongs of inquiry that owner must satisfy are: 1, whether the IMD tenant is deceased; 2, whether the application was timely filed; and 3, whether there is a claim for succession rights. Owner satisfied the first two prongs by submitting a death certificate proving tenant died on January 3rd, 2017, and timely filing the abandonment application on November 6, 2017, which is within 1 year of tenant's death. Owner, however, failed to satisfy the third prong. Owner did not provide sufficient proof that no one has asserted a succession claim for the unit. In the abandonment application, owner stated tenant lived alone. However, the application is silent as to whether anyone requested to succeed tenancy. At the oath inquest, owner's attorney stated he did not receive an answer to the abandonment application. However, failure to answer does not mean no one asserted a claim of succession. As owner failed to meet all three prongs of the abandonment analysis pursuant to Section 2-10F, owner has failed to meet its burden of establishing a prima facie case for abandonment. For the reasons stated, the proposed order before you today denies the application.
Okay, thank you very much, Mr. Clark. Is there a motion then to accept this case? Okay, that's Mr. Barwood. And second? Thank you, Mr. Rowland. Do we have any questions or comments?
I just have a odd comment.
Comments, I'm
Odd
sorry.
comment. I think to say that the tenant abandoned the case and then say that the tenant died, I should think it should go the other way. Tenant has deceased, ergo is an abandonment of the space. Because to say the tenant abandoned the space and then he died, it means that maybe the tenant decided to leave the space even before he died. So that, I must say that that language is always trouble.
Could that be a fact also?
That could be a fact. But that language is always trouble.
What was the fact?
I don't like to nitpick, but anyway.
He died. Any other comments? I mean, does what Mr. Morris just say need to be addressed in the order? Is that?
Yes.
I don't think so.
You really can't do it, you really can't do it that way. I understand what you're saying, and it does make sense, but you really can't do it that way.
All right.
Stick to Robert's rules there. Any other comments? Mr. Rivera?
Mr. Carver?
Yes.
Mr. Barrett?
Yes.
Mr. Bush?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
Yes.
Mr. Schechter?
Yes.
Ms. Torres?
Yes.
Ms. Roseman? Yes. Chairperson Henson?
Yes.
9 in favor.
Thank you, Mr. Rivera. The second case will again be presented by Mr. Clark. It is 222 Barrett Realty Corp. at 222 Varus Street in Brooklyn, docket number LB0193.
On July 19, 2018, owner filed an application seeking a finding that tenant abandoned the unit pursuant to 29 RCNY Section 2-10F based on tenant's death. Although owner's application is uncontested, Section 1-06I4 requires owner to present a prima facie case demonstrating entitlement to the relief sought. The three prongs of inquiry that owner must satisfy are whether the IMD tenant is deceased, whether the application was filed timely, and whether there is a claim for succession rights. Owner satisfied the first prong by submitting tenant's death certificate showing tenant died on March 18, 2018. Owner satisfied the second prong by timely filing the abandonment application on July 19, 2018, which is within 1 year of tenant's death. Finally, owner satisfied the third prong when the building manager, who worked for the owner for 25 years, testified that no one has paid rent for the unit and no one has sought succession rights to the unit since tenant's death. In addition to the building manager's testimony, owner submitted affidavits from the Kings County Surrogates Court stating tenant was never married and tenant's only child resides in Florida. Furthermore, owner listed tenant's only child as an affected party, and she was properly served with notice of the proceedings, including a notice of default to which no affected party sought relief. The evidence presented by owner sufficiently satisfies all three prongs of the abandonment analysis based on tenant's death. For the reasons stated, the proposed order before you grants the application.
Thank you, Mr. Clark. Do we have a motion to accept this case? Mr. Carver, is there a second? Mr. Hernandez, do we have any comments on this case? If there are no comments, then Ms. Rivera, would you please poll the board members?
Mr. Carver?
Yes.
Mr. Barrett?
Yes.
Mr. Bush?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
Yes.
Mr. Schechter?
Yes.
Ms. Torres?
Yes.
Ms. Roseman?
Yes.
Chairperson Henson?
Yes.
9 in favor.
Thank you, Mr. Rivera. The next case, the final case, is Jen Gatien at 43 to 49 Bleecker Street in Manhattan, docket number TA0222. And Mr. Clark will again present.
On July 5th, 2016, tenant filed an application seeking a determination setting the current maximum permissible rent for the unit. To MDL Section 286-2I and 29 RCNY Section 2-06.2 B4I, if tenant had a rental agreement in effect on June 21st, 2010, tenant is entitled to pay the same rent specified in the agreement in effect on June 21st, 2010, and paid by the tenant. The issues presented in this case are whether the maximum permissible rent is $3,000 per month, including utilities and real estate taxes, and whether net lessee is entitled to a 4% annual increase. Tenant testified that in May 2010, instead of continuing to pay monthly statements with utilities and real estate taxes that varied from month to month, she entered into a rental agreement with the prior net lessee to pay a flat rate of $3,000 per month starting June 2010. Tenant further testified that prior net lessee continued to charge and tenant continued to pay a flat rate of $3,000 per month for the rent from June 2010 through March 2011. Tenant supported her testimony by submitting a rent invoice in June 2010 that reflects rent due of $3,000. Net lessee makes 3 arguments in opposition. First, net lessee argues that because tenant paid less than $3,000 for the months of July, August, and September 2010, there was no rental agreement for the flat rate of $3,000. However, we accept the oath judge's finding that tenant credibly testified that she paid part of the monthly rent for those months with cash. Next, net lessee argues that tenant's payment of $3,099.47 for rent in May 2010 is proof that escalators were included in the original rental agreement. However, the rent specified in the rental agreement in effect on June 21st, 2010 is the determinative amount for tenant's rent, and therefore the May rent is irrelevant. Finally, net lessee argues the rental agreement was an interim agreement. However, the evidence supports a finding that a new rental agreement, including a flat rate for rent, utilities, and real estate taxes, started in June 2010. The next issue is whether the rental agreement in effect on June 21st, 2010 provided for a 4% annual increase. At a minimum, tenant must have agreed to the 4% increase in the rental agreement in effect on June 21st, 2010, and there is no evidence in the record that tenant agreed to the increase. Tenant credibly testified that prior net lessee informed her that he was subject to a yearly increase, but did not inform her that she would be responsible for paying part of that increase. The prior net lessee also admitted that he was uncertain as to whether he previously made it clear to tenant that she would be responsible for paying the 4% annual increase, and therefore tenant established that she and prior net lessee did not agree to the increase as part of the June 2010 rental agreement. For the reasons stated, the proposed order before you today sets the maximum permissible rent at this time at $3,000 per month, including utilities and real estate taxes, and net lessee is not entitled to the annual increase.
Thank you, Mr. Clark. Do we have a motion to accept this case? Mr. Delaney, is there a second? Mr. Hernandez, thank you, Mr. Hernandez. Any comments on this case?
I must abstain from this. This building joins the building that I live in for reasons I won't get into.
Thank you, Mr. Barber. Ms. Rivera.
Mr. Carver?
Yes.
Mr. Barrett?
Abstain.
Mr. Bush?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
Yes.
Mr. Schechter?
Yes.
Mr. Torres?
Yes.
Ms. Grossman?
Yes.
Chairperson Henson?
Yes.
8 in favor, 1 abstain.
So, we have some attorneys' presentation that we should have had originally on January 31st, and that is being postponed through to February 14th. So, at our January 31st, 2019 meeting, we'll discuss rules outside of protected occupancy discussions, right? Also, for our February 14th meeting, the attorneys have asked for a panel discussion format, and each attorney should present a 3 to 5 minute statement followed by a discussion with the Loft, with the board, being able to question, with the board being able to question any of the attorneys about particular points. So we just need to discuss that right now. Ms. Balsam may lead that discussion.
The only reason I ask is that in November, when the board had agreed to have the attorneys come, we had set up a different structure. So I just wanted to make sure, which would be that each attorney would present, there would be questions, and then the next attorney would present, and there would be questions. So I wanted to make sure that the board is okay with this kind of panel format that they're proposing. So I'm asking you.
Wasn't the concern about time, that we were worried that having too many attorneys are not limiting their presentation time? We were trying to not control the format as much as coming up with a format that we thought would rein it in from being an open-ended meeting that could go on for hours and hours and hours.
So I think in terms of time, we would still allot the same amount of time for the meeting total, but the attorneys are asking to spend it differently, to make short opening statements, and then to be able, I think one of their concerns was that they wanted to have both sides be able to answer questions. So if a question is raised before one attorney, maybe attorney number one, maybe attorney number three would want to address that question also. So they apparently have done this before in other forums, and they feel that this is a better way to do it. I don't know, I will take them at their word, but it's your decision, not mine.
Their opportunity to debate each other.
Yes.
So that we're just present at their own debate.
Well, you can
They
ask-
be doing this at dinner and doing it on their own, but we're not just going to be present to it.
Well, you can ask questions. I mean, I think
Right.
the idea was that you would be able to interject questions so that you would have.
Participation.
Right.
And initially we had said 15-minute presentation per attorney. So now we're talking about a 3 to 5 minute opening statement. So that leaves a little room there, to discuss.
How many attorneys?
And
Four.
4. And so we're thinking, the fact that they all agreed to this format, is a help. That we just have to have good a good moderator to kind of keep them in check.
Right, but that's kind of what I was thinking,
Yeah.
that if we say, we don't want to
On the response.
we don't want to get stuck on the
Yeah.
first
Yeah.
discussion, and all of a sudden it's been 2 hours and we've only talked
Yeah.
about one topic because it was a really heated debate, and it was interesting, but we only talked about one thing, right?
Right.
Like, so
Yeah, good point.
Is there a way to ensure that there is some sort of moderation so that if there are 15 minutes per each lawyer, or 4 lawyers, that they stop? Because otherwise I think,
Yeah, I mean, I'm the moderator, but I was going to maybe mimic after like the presidential debates where you would get a certain amount of time to answer the question. So maybe after the board member gives you questions you about something, you may have a minute to just respond.
Right.
And then if time allows, you can always come back.
Are the lawyers choosing the issues that they feel are the most?
No, I sent them, the board voted on this. It's in the minute. Yeah, no, I know. It was the board voted on it, and I sent them the topics.
Okay, so they're still
I
using that.
forget the exact language now, but the board was very specific in terms of what they wanted them to address, and that's what they're supposed to address. So.
And so they would just get this opening statement for each of them. We'll discuss if they all open, maybe, and then we have the questions, or if each person open, and then we.
No, I think they
They're
would all open, they would
all
all
open.
do an initial statement, and then it would be more
Yeah.
amended.
So I'll kind of put that out, maybe by the January 31st meeting, I'll kind of let the board know how the format's going to be.
I guess if you just recirculate, I forgot the
Yeah.
questions.
Sure.
Can we also request that as part of their opening statement, they give us, so they're obviously land use attorneys, we'll have their names, but somehow maybe what type of land use law they practice a little bit? So we get a sense of where they're coming from.
Short bios? You want short bios?
Yeah, that would be great.
Yeah, fine, okay.
Maybe in the interest of time, we could get those ahead of time in writing, so we don't chew up time.
Okay.
So they don't work for me, but I will ask. You're doing this as a favor?
I'm sure they'd be happy.
Well, even as something as short as, I've done a lot of moderation, or I only work for tenants, or I only do something.
Okay, maybe if they will give us a short bio and before that, and we'll ask them for that. If not, they can always do it when they go on the record.
I'll also look on they have websites, so I can look on their websites.
All right. So are we in agreement to this change in format? Is that all right with the board? Do we have to vote on this, Mr. Burrows? No? Okay.
My only suggestion would be, so we don't lose time explaining to the attorneys what the format is, if we could kind of maybe just have it sent out to, maybe we look at it on the 31st.
Okay.
And then send it to them so that everybody's clear on the ground rules, so we don't waste time saying, oh, I didn't know that, why is that?
Okay. Yeah, anyone else? Yes, Mr. Carr.
Yeah, I just have one more suggestion. I think prior to the start of their thing, Helene, if you could spend 5 or 10 minutes with us, and maybe with the chart, really simple. These are the 4 big issues that are being addressed. And our current rule says X, it says W, X, Y, Z, and the proposed rule that you have out there says A, B, C, D.
Sure.
So that right in front of us, we can either hang it up on the board there, that we have these salient points, there aren't that many of them, and show what the current state of affairs is and what the proposal is.
Sure.
Is that to keep the focus?
Well, certainly to keep my focus.
As a lawyer, he knows how lawyers go on.
All right. Very good. So we're going to do rules, but obviously we have 2 meetings this month. I'm going to make that decision now to cut this meeting. And we'll see you again in 2 weeks. So I'm going to close this meeting, and I'll just read my closing statement. This will conclude our January 17, 2019 Loft Board meeting. Our next public meeting will be held January 31st, 2019 at 1 p.m. at 280 Broadway. 280 Broadway on the third floor conference room. Board members, please remember to give me your attendance sheets. Thank you.